All rise. Veuillez vous lever. Please be seated.
I hereby inform the parties that 20 minutes extra causes no major problems for all those who are supporting us. Further, I would invite the parties to see whether they can agree on Thursday, whether they would have 2 times 1.5 hour in one stretch, or whether we still would stick to the 1 hour and then a break and then another half an hour. I leave that to the parties, and of course the defense will consider the position of Mr. Mladić in this respect. Please proceed.
Thank you, Your Honors. Before I proceed, I'd like to indeed correct what Your Honor brought to my attention when I was referring to D1413 in relation to the meeting in Dubanovci. I should have been referring to D410 in evidence, and that is entirely my error, and I thank Your Honors for bringing it to my attention.
Please proceed.
Should this chamber find that Count 11 is not defective, Count 11 still fails on the merits as set out in Section 6 of our final brief. First, I will address self-defense and unjustified NATO bombings. Then I will address how Count 11 fails for 4 reasons. First, a legitimate basis to detain existed. Second, improper treatment was perpetrated by paramilitaries. 3, VRS ordered compliance with Geneva Conventions. And 4, no reliable evidence proves a JCE. Contrary to the prosecution's portrayal of justified NATO bombings, the NATO attacks that sparked prisoner of war detention sprung from an unfair situation, where the UN had previously agreed to allow weapons withdrawal from weapon collection points in self-defense, and then went back on that agreement. If you can have next slide. First, around 14 February 1994, the protocol between UNPROFOR and the VRS delineated that, quote, the BSA reserves the right to implement adequate measures of self-defense, end quote. D112, page 4. GRM 097 confirmed that weapons collection points were established around Sarajevo, quote, so that if attacked, they could then defend themselves, end quote. Transcript page 40119. Importantly, if attacked, the party that was attacked, therefore, was no longer bound by the demilitarized aspect of that agreement. Again, 40119. The protocol in question demonstrates UN involvement and uses the term BSA, which is UN lingo, and appears on UNPROFOR command fax letterhead. As of August 1994, BIH activity had already prompted the VRS to withdraw their weapons. D112, para 1 to 3. On 5 September 1994, UNPROFOR came off the original agreement, including the right to self-defense, saying that they, quote, did not endorse this position, end quote. That's at P631, page 1. The Bosnian Muslim side was equally restricted, but around March 1994, the Serb side had already reported at UNPROFOR the repeated violations by the Muslim side. D111 is evidence of that. UNPROFOR did not conduct airstrikes against Muslim forces for violations because of American and NATO reluctance to act against the ABIH. We heard about that from GRM 097, GRM 037, General Rose, and Mr. Harland. In witness Dragicevic's words, UNPROFOR had sided with the Muslims. D. 554, paragraph 31. Therefore, the Serb side withdrew weapons for self-defense. The UN ignored this legitimate purpose, bombing them instead. Turning to the legitimate bases to detain. Serb forces ultimately did not consider UNPROFOR to be neutral, but rather combatants. GRM 037 told us about that. It is necessary to show that the violation was committed against persons who were not directly involved in the hostilities. That's what the Mladić trial judgment tells us at paragraph 177. Thus, the legitimate bases to detain UN combatants excludes UN POWs from Common Article 3. Equally important, this legitimate detention substantiates that the VRS detained personnel to prevent more bombings. Evidence substantiates a reasonable alternative, that UN personnel were detained as combatants as they were exchanging gunfire, P591, holding territory, D554, enlisting NATO airstrikes, P2558, guiding pilots to Serb targets, P6644, collecting intelligence against Serbs, transcript 39023, smuggling weapons to the enemy forces against the VRS, D535, and even taking VRS soldiers prisoner, D1586, P2558. Around 27 May 1995, RM401 testified about the UN's armed retaking of a bridge assisted by ABIH, quote, support fire, end quote. Example, that means the ABIH was shooting to cover and assist UN personnel. That's at transcript page 18260. This substantiates that VRS could have reasonably perceived the UN and the ABIH as cooperating, that the UN were combatants. Around 28 May 1995, in reaction to how the UN had taken detained Serb soldiers, this memo declared that, quote, UN has not the legal right to hold prisoners of war, end quote. It describes that, quote, the credibility of UN regarding international humanitarian law is also deranged if such a practice is being implemented, end quote. Again, that's D1586. Not one occasion occurred where UNPROFOR requested and launched NATO to bomb the Bosnian Muslim side. On the other hand, UN personnel recorded the VRS locations, and some trained as airplane spotters acted in that role. For targeting, UN ground personnel communicated to the NATO pilot directly. General Smith told us about that. During the testimony of UNPROFOR General Nikolai, Judge Ori asked, quote, had UNPROFOR provided assistance to NATO to define those targets on Bosnian Serb territory? The response was, yes, the targets were determined at UNPROFOR headquarters in Sarajevo, and that information was subsequently relayed to NATO with a request to fire there. UNPROFOR endorsed the large-scale NATO airstrikes of May 1995, D1468, page 9. The Bosnian Serb leadership considered that the UN had become combatants. General Smith's now declassified correspondence to the U.S., not to his UN superiors, but to the U.S., reports on 27 May 1995 that, quote, "I've broken the machine." That's D1462. On 28 May 1995, another declassified cable details Smith advocating that the only options are to become unsustainably weak or to wage war. D452. In his ICTY statement, General Smith conceded, "We were never peacekeepers because there was no peace to keep, and we were bombing one party." Sayers also reported a Pakistani UNPROFOR colonel taking the Bosnian Muslim side when an UNMO reported that the Bosnian Muslims were shelling their own village to blame the Serb. This colonel responded, "You are liars." D1465, page 11. Improper treatment was perpetrated by paramilitaries, as in our final brief, paragraph 3349 to 3386. Importantly, VRS officer Mladić was tasked by General Tolomir with taking over and securing UN detainees. Mladić took over as the primary guard, and no one was maltreated. D1224, paragraph 9. The Red Cross visited them in June 1995 without complaints. D1227. As to the bridge, RM401 first described captors as Bosnian Serb forces, but clarified that the majority were militiamen. P2537. This meant, quote, "people who take up arms, who put uniforms that they find on the ground, and they operate with or without uniforms, and they take part in fighting next to the regular army." That's what RM401 said at 18238 to 18239. RM401 was reassured of being handed over to the Serbian Regular Army, P2537. Once in VRS custody, detainees were treated according to the Geneva Conventions, which were read aloud. Transcript page 18263, again, RM401. VRS orders substantiate the intent of the VRS to treat UN personnel as POWs, including IHL brochures. One VRS order on 27 May 1995 states, "Make sure that UNPROFOR are treated properly as prisoners of war." P789, paragraph 4. Colonel Shechowatz detained POWs, stressing that, quote, "We did not mistreat them. We abided by the Geneva Conventions," end quote. Transcript page 24052. Around 26 May 1995, as the French contingent had received orders not to surrender, the VRS and French agreed for the VRS to shoot outside and for the French to then surrender. P6717 and transcript page 25215 to 25217. From this, it is clear that UN personnel and the VRS cooperated to peacefully resolve the issues. No one was ever endangered. Evidence substantiates proper POW treatment. Witness Cornish testified that detainees used the radio to report back hourly. He also said that they were allowed to wash their clothes. Witness Mladić confirmed that the detainees, the POWs, wrote letters and received the Red Cross. Several witnesses, including General Riley and Colonels Radojcic and Shechowatz, even testified that UN personnel held as POWs were even permitted to keep their weapons. No reliable evidence provides a plan or agreement involving the accused. Literally nothing. In an alleged intercept from 28 May 1995 between General Smith and General Mladić, that's P790, Mladić claimed the hostages were held by the VRS, but only to posture. First, paramilitaries committed the impermissible acts against a few UN personnel. Secondly, General Mladić learned about this, like everyone else, on the TV. Third, General Mladić ordered his troops, via General Tolibir and via Mr. Vojvodić, to take over and detain these persons as POWs. And then, fourth, General Mladić speaks to Smith, tacitly taking responsibility for bad acts to try to gain an upper hand. Fifth, the general's bluff does not work, but no more POWs are put at the radio antennas or in harm's way after he has this discussion with General Smith. So there are no acts that can be tied to a criminal nature from the words that General Mladić uttered in this conversation. Therefore, Count 11 fails because the indictment is defective, and even based on the evidence, it cannot be said that the only conclusion is that the VRS, under Mladić's orders, took UN personnel as hostages in order to deter NATO strikes. Instead, the evidence demonstrates legitimate detention of combatant POWs. They were treated in accord with the Geneva Conventions. No conviction can arise for Count 11. I will now move to the topic of mitigation and sentencing submissions. I hope that we've been abundantly clear in our final brief, particularly section Romans 7 of the same, pages 899 onward, as well in the past days in our oral submissions, that we believe the only fair and just outcome is an acquittal, due to the fact that the prosecution has failed to meet its burden of proof as to General Ratko Mladić. However, as your honors know, but the public may not know, we are required by the particular rules of the tribunal to make these submissions now. I will not repeat too much submissions already made in our brief. The prosecution's comments the other day are inappropriate. Everybody deserves mitigation if it exists under the evidence, especially General Mladić. ICTY jurisprudence states that expressions of remorse can be recognized as a mitigating factor if the remorse is real and sincere. Indeed, prior ICTY cases, like the Orich trial judgment, have considered remorse even where the accused made no statement, but where throughout the trial the counsel expressed it on his behalf. That's at paragraph 752. In the instant case, counsel have repeatedly made expressions on behalf of and at the instruction of the accused. Some illustrative examples include, in relation to witnesses, RM 084, RM 079, RM 010, RM 115, and RM 291. There's likewise evidence of Mladić's own statements that demonstrate remorse. We highlight one such instance introduced by the prosecution through Commander Rupert Smith. Mladić is recorded in relation to Markale to have said, quote, "Our side does not have any high-impact projectiles of this kind, one of which could hurt so many people, and I'm very sorry for the misfortune which befell all these people, be they killed or wounded," end quote. That's P789. Another instance is the evidence that indicates he only found out about some killings having taken place in Srebrenica after the fact and was visibly upset upon learning of the same. Witness Simic talked about that at transcript page 32589. After finding out, Mladić was visibly distraught and worried and condemned the acts as being horrible. Witness Todić talked about that, D798, paragraph 28. He further stated that whoever is responsible for those acts must be crazy. The same citation, D798, paragraph 28. If the prosecution promotes the purported notebooks of the accused as authentic, then they must also accept that these purport to show the accused advocating a commission to be formed on the basis of equal parity to really investigate all the deaths and killings around Srebrenica. P348, page 47. Next, I move to the sentencing provisions of the SFRY, which prohibit any sentence exceeding 15 years or 20 years for the most atrocious crimes. Although this tribunal has decried that it is not bound by the SFRY sentencing practices, this tribunal is bound by international law, i.e., it must apply the law that was in force at the time of the commission of the crimes. Nullum crimen sine lege, nulla poena sine lege. Consequently, any sentence that would exceed the parameters of the 1976 Criminal Code of the SFRY would be a violation of the principle of legality and of the prohibition of the retroactive application of the law. Similarly, the European Court of Human Rights has recently affirmed this same rule as to Bosnia and Herzegovina. It should apply to this tribunal as well. The law in force at the time of the commission of the crimes alleged was the 1976 Criminal Code, which remained authoritative until 1998 in the BIH and 2000 in the Republika Srpska. It dictates that war crimes are to be punished by imprisonment that falls within 5 to 15 years, or by the death penalty for the most serious crimes. Nevertheless, the death penalty was abolished by the Dayton Agreement and substituted by the possibility to impose a 20-year term. The prohibition on retroactivity inherently implies a prohibition on the retroactive application of lex gravior, i.e., of the more severe penalty. Consequently, it is unlawful to impose a heavier penalty which did not exist at the material time of the commission of the crimes. It is a widely recognized principle of international law that whenever a crime is punishable under two successive provisions, one of them being more lenient, the lesser should be applied as per the favor liberatis principle. I refer you to the Maktov and Demjanovic versus BIH decision of the European Court of Human Rights, page 11. Likewise, from that same decision, page 46, the prohibition on retroactivity is part of customary international law and a peremptory norm of international law, therefore permitting no derogations. In dealing with the very same issue, the European Court of Human Rights deemed the application of the 2003 BIH Criminal Code instead of the 1976 SFRY Code to be unlawful and a breach of the applicant's rights, page 32 of the Maktov-Demjanovic decision. In sum, the application by the Chamber of a penalty not envisioned under the applicable law at the time would be a violation of the customary international law norm prohibiting the retroactive application of the law. Consequently, the Chamber is under an obligation to ensure that the penalty falls within the 5 to 15 years parameters or 20 years for the most serious crimes that would otherwise have been punished by the death penalty. Not doing so would mean that the tribunal is acting ultra vires. What message would this tribunal be sending the world if it persisted in sentencing practices that the European Court of Human Rights has now forbidden domestic jurisdictions from pursuing as unjust? We submit that the very legacy and reputation of the ICTY is called into question if it opposes and acts in violation of the standards proclaimed by the European Court of Human Rights. I now turn to the prosecution's assertions as to aggravating circumstances. The prosecution has failed to prove beyond reasonable doubt an abuse of the accused's position of authority. In any event, a high-ranking position of authority is not per se deserve a more severe sentence, and in any event, the accused did not abuse his position of authority in any manner whatsoever. The prosecution repeatedly emphasized that there was a clear hierarchy within the VRS within which orders had to be respected. Nevertheless, this clear hierarchy is irrelevant in respect to the accused's liability, since no order that could connect him to the crimes has been put forth by the prosecution. Again, as to Srebrenica, prosecution expert Richard Butler stated that he had not come across any orders from the accused ordering the commission of the crimes. It is therefore unreasonable to say, in light of the evidence, that the accused abused his authority for criminal purposes. In any event, this chamber should reject this ground as an aggravating factor because it has not been raised by the prosecution in the indictment, and as such, it is not meeting the conditions for aggravating factors. The prosecution has argued the special vulnerability of victims as aggravating. Such an approach is not allowed to be taken into account twice due to the prohibition of double counting, insofar as it has already been subsumed in the overall gravity of the crimes. Look to the Kordich and Shirkez appeals judgment, paragraph 1089, and the Stockich appeals judgment, paragraph 413, and the Galich appeals judgment, paragraph 408. In its submissions at paragraph 1743 of their final brief, the prosecution can only put forward anecdotal evidence which bears no legal significance and has failed to bring forth any appropriate expert reports or studies. The prosecution likewise maintains that the accused should get the maximum sentence solely because he should get a higher sentence than subordinates. This is completely at odds with and incompatible with the principle of individualization of the penalty and legal certainty. Such a position by the prosecution represents a conviction by extension through collective guilt. Again, it goes back to the desire to pump up Ratko Mladić to superhuman proportions, to make him the symbolic sacrificial lamb for the perceived guilt of all Serbs, as perceived and assessed by the prosecution. Another prosecution claim made at paragraph 1741 of their final trial brief is that the accused took a dominant role in the commission of the crimes by not respecting IHL. But this is directly refuted by the many orders and evidence from the accused commanding the exact opposite. Further, the prosecution claim at paragraph 1737 of their final brief that Mladić's subordinates summarily executed thousands in Srebrenica, but this is irrelevant absent the required nexus. It is also impermissible double counting in that this is subsumed in the crime alleged. Now I would ask that we go into private session.
We move into private session.
Back in open session. Yeah.
Thank you, Mr. Registrar.
From Mr. Darko Mladić's statement, we see that the accused raised him with a spirit of helping everyone, regardless of ethnicity. The most important thing was to be a good human being, paragraph 8. And Mr. Darko Mladić details various good deeds performed by his father to assist non-Serb civilians, both during the war and outside of the war. We consider that to be evidence in mitigation. In summation, we ask you to reject the prosecution's efforts to apply collective guilt, to build up Mr. Mladić to superhuman proportions, and their call for you to act contrary to various legal maxims in imposing a life sentence. The appropriate standard and legal principles dictate that any sentence should be limited and minimum in nature due to the mitigating and other circumstances enumerated. Your Honors, for all the reasons stated these past 3 days, the defense would submit that the prosecution has failed to meet the requisite burden of proof as to any of the counts and charges of the indictment. It simply did not present the evidence necessary to prove its case and support the allegations it made in the indictment. We thus feel that the only just verdict would be an acquittal. Now I would like to take just a few moments to address some additional words. Your Honors, today my client speaks through me as his attorney, and it is his words whose burden that I now turn to speak to you. It is a heavy burden to speak for a man who has been so completely and deliberately misunderstood, who has had to listen to vicious allegations against himself day after day. It is a difficult position that not many of us could endure quietly. At times, his emotions have gotten to him, and as you know from the medical records, his medical condition is such that it is not his fault. It is a medical condition that contributes to emotional outbursts. With this tribunal unable to accommodate his medical condition, do not hold it against my client that you expelled him from court in the past. But more importantly, try to see things from his perspective. And to prepare for today, I task myself with the same task. And to do so, I looked at what my client said in the Mladić proceedings on 28 May 2014, when he was summoned by the power of subpoena to essentially be forced to potentially be a witness against his own interests in a case under the same indictment. Therein he stated, and now I quote from that transcript, the witness, Mr. Kwan, ladies and gentlemen, as for this Hague Tribunal, this court, I cannot stand it, and I do not recognize it, and I cannot testify before it. I cannot take an oath because this is pressure against me as a person, against my health, against my people. These continue to be sanctions, and things have really been brought to an end. I kindly request that you give me the following possibility. With all due respect to President Radovan Karadzic and the efforts that he made and has made for the salvation of our people, and I contributed somewhat to doing some good, I wouldn't want this trial to fail. So I would like to ask you, if you have the possibility and the time to hear me out. I wrote 7 pages last night before St. Sava's Day. Today is St. Sava's Day. So if you don't mind, I would like to read that out, and after that I can take an oath. I do not recognize this Hague Court. It is a NATO creation. it is a satanic court, not a court of justice, and it is trying us because we are Serbs, because we protect our people from you. And then Judge Kwan said, Mr. Mladić, I'm cutting you off. Please be seated. I will consult my colleagues. Mr. Kwan then said, yes.
Did you say the Hague court or the Hate court?
Hague court with G.
Thank you.
Mr. Mladić, as you know, we have our rules in which our proceedings should proceed. So I would recommend you, again, to take the oath, answer the questions, if you will, and the questions posed by Mr. Karadzic. And then there was a discussion again as to the rules of the procedure, and then my client finally said, Mr. Kwan, you are considerably younger than I am. You are exerting pressure against me for no reason whatsoever. I am not afraid of anyone but God. My conscience is clear with regard to all matters. Your subpoenas and your platitudes at the Hague Tribunal and your false indictments, I don't care one bit about any of that. I don't want to tire these people over there and all of you. I am going to make this statement, but I do not recognize your court, the Hague Tribunal. It does not exist for me. Now, that is what my client said. And I can tell you that he believed every word the day that he uttered it. For him, that was the truth. And I have to ask you, can we really blame him if his view of this tribunal is so negative, if it is based on how he has felt, based upon how he feels he has been treated since coming here? I want you to appreciate where he's coming from, and in rendering your verdict and judgment, to try your best to prove him wrong. Because I have been unable to come up with arguments to convince him otherwise, though I've tried. And can you really blame my client for having such a negative view? If we can have the next slide. This is the motto that hangs in the lobby of the tribunal, and it shows no respect nor acknowledgement for the presumption of innocence, nor the protection of the rights of the accused. It just says, bringing war criminals to justice and justice to victims. Can you really blame my client for having a negative view, given that you ejected him at the time of the initial appearance, for merely trying to invoke his right to waive reading of the indictment, a right all my prior clients enjoyed and exercised? Instead, you kicked him out and read the indictment anyway. And the next accused who was arrested, Mr. Hadžić, he simply asked the court not to read the indictment, and this was complied with. Can you really blame my client for being leery of the fact that 2 out of the 3 judges have made affirmative findings of guilt against him? You, Judge Ori, in the Mladić case, and you, Judge Fluge, in the Tolimir case. Can you really blame him for being skeptical about these proceedings and his rights being protected, given that both the president of the MICT, who made a public statement to the victims of Srebrenica that Karadzic and Mladić will be brought to justice, and the ICTY president, who made affirmative findings of guilt in the Popović case against him? Can you really blame my client for being afraid of injustice, given that the Karadzic case also made affirmative findings of guilt in the judgment against him, and then your honors brought over the helpers from that case to draft this judgment, which you have recently acknowledged might already be in the process of being written? Can you really blame my client when the appeals chamber has already, in the Popović appeal, again made multiple findings of guilt against him in another case where he could not defend himself? Can you blame him in this case where the prosecution was allowed to eavesdrop on his communications with counsel and thus break the attorney-client privilege? Your honors, you have to understand and appreciate why my client does not trust you. And now your job is to look at all the evidence, and I hope that you will do so and take the opportunity to do what I cannot do, which is to convince my client that this tribunal is fair and is just, and that you will fairly appraise the evidence and not bow to prosecution arguments or political pressure. And you'll make sure that the highest standard of the burden of proof pyramid is applied. I hope that you do, and I hope that you prove my client wrong. And in doing so, hopefully you will enlighten those persons out there in the public, out there, who might feel the same way my client does. An acquittal would prove my client wrong and would send a strong and enduring message as to the legacy of this tribunal as one of justice. And I, for one, sincerely hope you choose that path. Lastly, we heard Mr. McCloskey read a poem or letter from the American Civil War last week. I don't have anything like that, and in any event, I'm not sure if that is relevant to our proceedings. General Mladić has asked me to leave you with something more relevant and meaningful. We have been speaking over the last 4 years about very specific issues and incidents. And it's very easy in a case like this to lose sight of the bigger picture. War is ugly, and in the end, its violence does not discriminate. General Mladić is a military man, but he watched his country descend into chaos and tear itself apart. It has shaken him profoundly, and in ways that this court can never begin to understand. He therefore has just one request. He would ask that we take 1 minute of silence to remember and commemorate all the victims of the senseless war in Bosnia-Herzegovina, a war that I might add he neither started nor prolonged. And when I say all victims, General Mladić wishes me to specify that he and the defense team considers every life lost in the war, every Bosniak, Serb, Croat, Roma, Albanian, every man, woman, and child a tragedy. And this list of victims includes the 1,300 Serbs of the Srebrenica area who lost their lives to Nasser Orić's horrific violence and whose voice has not often been heard in this place. May their memory be eternal, and may mankind have learned from their lessons, because today we sorely need them. And that is all that General Mladić wished me to leave you with. So I leave it in your hands, Your Honors, if we will have the 1 minute of silence or not. I have no further submissions. Thank you.
Thank you, Mr. Ivitic. The request you passed on from Mr. Mladić is denied. It doesn't fall within the scope of our task. And we'll adjourn for the day. We will resume on Thursday, the 15th of December. And could I hear from the parties whether they have reached an agreement to have it 2 times 1.5 hours, or whether it would be 3 sessions split up the middle session?
From the defense side, we have no problem with the proposed 1.5 hour, then a break, and 1.5 hour sitting.
We didn't propose anything, but if that's what the parties prefer, and if you have no problems, then we will head for 2 sessions of 1.5 hour. Therefore, we'll adjourn for the day and we'll resume on Thursday, the 15th of December, 9:30 in the morning in this same courtroom.
All rise. Veuillez vous lever.